And that takes me right to my theme this evening, which are rights. Rights are claims or entitlements. They can be useful things in language and in public debate, but there's long been skepticism about them. One needn't go back as far as Jeremy Bentham's famous description of natural rights as nonsense on stilts. His target was the notion of imprescriptible rights, namely those that aren't legally created, which he thought was nonsensical. More recent rights skeptics object precisely to prescriptible rights, namely those created by law. Some say, on the left, that the constitutional thought schema or rights consciousness are intended to secure the denial of desire in the face of contingency and the fear of loss by representing ourselves as legally compelled, and that in doing so rights merely create the reproduction of alienation, a condition of group membership. That's meant to be a joke, ladies and gentlemen, but it's too early in the lecture. No, someone really did write that. Less abstrusely, rights skeptics have contended that rights are simply too context-dependent or too wobbly and too woolly to be instructive about ourselves in the social frameworks that we live in, or to be politically useful in securing real improvements in people's lives. Whether rights should be entrusted to lawyers or to judges is especially controversial. In the High Court of Australia, Justice Hayden has recently denounced a piece of human rights legislation. This tasked judges with determining whether a law reasonably limits a human right. He said the language in which it did so was highly general, indeterminate, lofty, aspirational, and abstract. He didn't stop there. He said it was nebulous, turbid, and cloudy. The tasks it required judges to do, he said, were not tasks for judges at all, but tasks for a legislature. In your own country, Mr. Jonathan Sumption, QC, who has recently taken office in the Supreme Court. You were hoping I'd have a go at Lord Sumption, weren't you, ladies and gentlemen? Has charged that the European Convention on Human Rights has required judges to deal with the merits of policy decisions. In a democracy, he says, these are the proper functions of Parliament and of ministers answerable to Parliament and to the electorate. The Strasbourg judges, he has stated, regard the Convention not just as a safeguard against arbitrary and despotic exercises of state power, but as a template for most aspects of human life itself. For related reasons, some influential thinkers in my own country cautioned against including social and economic rights against government in our constitution. Their argument was that entrusting rights to judges instead of to the legislature alone would obstruct rather than help democratic transformation. To overemphasize the importance of rights, critics said, by introducing a battery of social and economic claims in a constitution is to place far too much power in the hands of the judiciary, which, however appointed or elected, is never as accountable to the populace as is the legislature or the executive. Precisely Lord Sumption's reservation. Theorists have even argued that rights talk is affirmatively harmful to social progress. This is because it enables powerful groups to insulate privilege and to silence challenges by vulnerable sectors of society to existing social power structures. That critique has taken a particular form in my country, where the insulation of rights is said to have secured the insulation of racial power to the white minority. And a strong critique has recently come in South Africa from the Deputy Minister of Correctional Services, Mr. Nwaku Ramatlodi. In addition to assailing the conceptual fuzziness of rights in general, rights skeptics therefore emphasize the role of rights talk in masking entrenchment of privilege and power, and in deferring or diverting action for change. And they question whether rights can be useful to securing progress in society. And I must say, rightly so. It is a bad business to put too much trust in lawyers and the law. Doing so mistakes the value of legal regulation. which is not to plan or initiate social change, or to make public policy choices essential to it. It is rather to resolve conflicts and to protect against mistakes in the exercise of power by measuring public decisions against a framework of constitutionally entrenched values. To trust legal regulation and legal rights too much overloads the legal system. It may strain, crack, or even break under the resultant political and social burden. But if we accept the limited value of legal rights, if we accept that the law is an adjunct social instrument, that it cannot mend society nor choose its ways, and that its remedies and rhetoric should be approached with skepticism, if we accept all of that, then we may nevertheless defend a modest role for legal rights. It is this, that the law and legal rights can, despite rightful misgivings about them, play a practical part in securing what a decent society should promise to its citizens. What rights can bring lies not only in tangible goods consisting in bricks and mortar, but also in less tangible benefits that resonate in people's sense of well-being and entitlement. My argument is that South Africa's experience of democratic constitutionalism and the rule of law, and indeed of rights talk, over the last 18 years since the end of apartheid, powerfully instances what can rightfully be achieved with rights. Constitutionalism in my country has not been a panacea, nor has the jurisprudence giving effect to it been flawless, but it has secured some signal achievements, and these should be celebrated.